Thank you, all of you who've joined us so promptly for this webinar for institutional investors on climate policy chill and investor state dispute settlement, or ISDS. We're going to get the webinar underway now, so I'll just stop sharing my screen. And thank you all for joining so promptly. My name is Sarah Bruin. I'm from the Australasian Centre for Corporate Responsibility, or ACCR, where I'm a company strategist, and I'll be the moderator for today's webinar. ISDS, or Investor State Dispute Settlement, the topic that we're here to discuss today, is a legal regime that's been described as, quote, litigation terrorism by the Nobel Prize-winning economist Joseph Stiglitz. It's been described as the wild, wild west of international law by one of the preeminent lawyers practicing in this field. And the UN Special Rapporteur on Business and Human Rights last year described it as, quote, a major obstacle to the urgent actions needed to address the planetary, environmental, and human rights crises. In its sixth assessment report, the IPCC warned of ISDS concerns resulting in governments, quote, refraining from or delaying the adoption of mitigation policies such as phasing out fossil fuels. So what is ISDS? How does it work? How do companies use it to influence governments in their climate policy making? And why does any of this matter for institutional investors? Those are some of the things that we're here to grapple with today. So I'm going to give a few quick housekeeping notes before I introduce you to our esteemed panelists. So firstly, to note, we have interpretation available into Spanish, and if you need to use that function, there should be some instructions in the chat for how to access that feature. There will be time for questions, so please feel free to put your question into the Q&A box at the bottom of your screen at any time. And this webinar is being recorded. So we will share the recording after the event with anyone who's registered, as well as sharing links to any of the references and resources that we refer to in the webinar. And one of those resources is an investor insight recently published by ACCR covering a number of the topics that we will be discussing today. And I believe one of my colleagues will be popping the link to that in the chat so that you have it on hand. Finally, there's a really important definitional point that I'd like to clarify at the outset, because it will be important to your understanding of the webinar. And that is that the I in ISDS stands for investor, but it means investor in the context of a foreign direct investor making an investment in a host country. So this is what we would think about in the investment world as the company. So for example, Exxon is an investor in the Netherlands for the purposes of the ISDS claim that it lodged against the Dutch government just last week. So we'll endeavour to use the word company consistently so as not to cause too much confusion with the concept of an institutional investor. I hope that has lent greater clarity to this point, and I'm sure my panelists as well will help to make it clear to you. So with those matters out of the way, on behalf of ACCR, as well as our co-organisers, the Centre for Research on Multinational Corporations, or SOMO, and Fair Finance International, I would like to introduce our esteemed speakers today. So firstly, we'll be hearing from Dr. Kyla Tianhara, who is an interdisciplinary social scientist who studies the intersection between environmental governance and the global economy. She's Canada Research Chair in Economy and Environment and an Associate Professor at Queen's University in Canada. And Kyla will be giving a presentation that will introduce the key concepts and trends relating to ISDS and climate policy making. We'll then hear from Simone Batafour, who is a partner at Curtis, Mallet, Provost, Colt and Mosel LLP, or Curtis for short, which is the leading firm representing sovereign states in ISDS proceedings. Simone practices international arbitration and public international law, and he lectures on ISDS and climate change. And he'll be sharing a valuable insider perspective on ISDS, including explaining how it differs from domestic litigation, how companies use ISDS to touch on all levels of government decision-making, and how the issue of compensation for lost profits is addressed in this legal regime. And then finally, we'll be hearing from Adam Gillett, who is a senior investment manager in the sustainable ownership team at Railpen, which is one of the UK's largest pension funds with around 34 billion in AUM on behalf of 350,000 members. Adam leads Railpen's climate change program and is also a member of the IIGCC lobbying working group. And he'll share his thoughts on why ISDS is relevant for institutional investors and what all of this means for institutional investors and their engagements with the heavy emitting companies in their portfolios. So with all of that said, let me please hand over to you, Kyla, for your presentation. Thank you.
Great, thanks so much, Sarah, and thanks for the invitation to be here. I think it's a great event to put together. So I'm going to attempt to very briefly introduce investor-state dispute settlements, or ISDS, and explain why it is an obstacle to climate action. So just starting with the origins of ISDS. So investment treaties first appeared in the 1950s and 1960s in response to concerns from foreign investors that had not required international legal protection during the colonial period. So these treaties were shaped by the former colonial powers, as well as institutions like the World Bank, and they were pitched to countries in the global south as tools to promote foreign investment and thereby economic development. Unfortunately, they have not had any demonstrable effect in that regard. So the key mechanism in these treaties that makes them so powerful and so problematic is that they provide a specific group of private actors, foreign investors. Again, to reiterate, this is essentially means companies. We aren't talking about institutional investors, with direct access to a system of international arbitration without first having to exhaust local remedies. In other words, these foreign investors can bypass local courts entirely. If a dispute goes to investor-state dispute settlements, or ISDS, it will be a panel of 3 arbitrators that will decide the case. One will be chosen by the state, one chosen by the investor, and then a third will be mutually agreed upon or appointed by an arbitral institution. Now that sounds pretty simple, pretty straightforward, but it is actually incredibly controversial. First, there are serious conflicts of interest that can arise because individuals can act both as arbitrators in one case and as a lawyer for an investor in another case. This is referred to as double hatting, something that would never be allowed in a domestic court system. There are also issues with a lack of transparency in the process. The proceedings in most cases are not open to the public, and documents are not always published. There are also very limited opportunities for third parties, such as environmental organizations or local communities that are impacted by a project, to actually intervene or participate in the proceedings in any way. The costs of these cases are, which can also drag on for many years, are very high. $5 million US is the average cost for states, but there are cases where governments have spent more in the range of $20 to $40 million. And then if award is made against a state, there are very limited options for challenging it. There is no appellate process, as we would see, for example, in the World Trade regime. As a result, there is a lot of inconsistency in how tribunals interpret the treaties, and this makes it very difficult for states to predict whether or not they will be successful in their defense of a policy. I don't have too much time to delve into the actual content of investment treaties, but I just want to give you a brief overview of the kinds of provisions that come up in these cases, and then we can follow up in the Q&A if anyone wants more details. So most investment treaties would include the following standards of treatment and protection. National treatment, most favored nation treatment. These are about non-discrimination. Protection from expropriation without compensation, which includes also protection against indirect expropriation, which is really about regulation rather than government actually taking over an investment. And then also fair and equitable treatment. There are others, but these are the ones that come up the most frequently in disputes over environment and climate policies. I just want to highlight briefly that fair and equitable treatment is both the most likely provision to be invoked by an investor in an arbitral claim and also the most difficult to pin down in terms of what it actually means. One of the most problematic aspects is the interpretation, which is quite popular among arbitrators, that states must meet the so-called legitimate expectation of foreign investors, which means that a company can argue that it didn't think a policy was going to change, and therefore it should be insulated from the impacts of that change. The bottom line here is that these provisions are vague, they are open to interpretation, and this gives a lot of power to ISDS tribunals and also creates a lot of uncertainty for governments. And just to note that it does seem that governments are starting to recognize that these vague protections and ISDS are an obstacle to climate action. So there's been a lot of work happening on this at the OECD in the past few years. And last year, they released the results of a survey in which the majority of government respondents noted that investment treaties do not currently provide clear parameters on policy space for climate measures. So moving on, I want to spend a bit of time on the industry that is primarily responsible for the climate crisis. And here I have sort of 3 take-home messages for you. The first is that fossil fuel investors are big users of the ISDS system. 1 out of every 5 cases is related to a fossil fuel project. There have been at least 349 cases so far, and many of those cases are recent and still pending conclusion. Most of these cases aren't necessarily directly related to climate policies, but this does demonstrate that the sector is adept at using the system and is quite happy to do so. Second, fossil fuel investors are also very big winners in the system. If a case makes it past the jurisdiction stage, then they have a 75% chance of winning, which is higher than the average across all other sectors. Third, they have won a lot in damages so far, at least $82.8 billion US. And that is money that has potentially been reinvested in more fossil fuel projects, further exacerbating the climate crisis. The next speaker is an expert on damages, so I won't go into that topic in any depth. Okay, so now that we have a bit of idea of how the fossil fuel industry has been benefiting from the system, let's look a bit more at some cases that I call climate relevant, because climate policy wasn't necessarily at the heart or the main source of the dispute, but nevertheless, these cases demonstrate what might happen if states enacted similar policies for climate reasons. I would stress that this is not a complete list. It keeps growing, and it's getting very hard for me to fit it into one slide. I would also just reflect on the fact that at the moment, most of these cases are against countries in the global north, but I actually believe that the risk is much higher for countries in the global south. And just to give one example here, there are 4 cases on this list that are related to companies that are wanting large compensation payouts for the phase out of coal power. And that is an area where I think there is a lot of potential for disputes to arise. For example, in a country like Indonesia, which has a lot of recently built power plants that are owned by foreign investors that are protected by treaties. And they are aiming to phase them out, but whether that's going to raise a lot of ISDS cases is to be seen. So I'll just go through a few of these cases that I'm sort of more familiar with a bit to give you a bit more of an idea. Here's one, the rock hopper case. This was in Italy, the government banned offshore oil developments along the coastline to protect the local environment from oil spills. And a British company that had an exploration license launched a case under the Energy Charter Treaty. They won 190 million euros plus interest and costs, which in total amounted to over 250 million euros. And I just want to highlight here that this award was nearly 7 times what the company had actually invested in the project. And they announced that they're going to take that windfall and invest it in further oil exploration in the Falkland Islands. So effectively, we have a system that is forcing Italy to subsidize fossil fuel exploration in another country. Next, we have TC Energy's case against the US over the cancellation of the Keystone XL pipeline. This was an incredibly controversial project that would have taken oil from the Alberta tar sands in Canada across several US states and down to refineries in the Gulf Coast. It was first canceled by President Obama in 2015. He was citing the need to demonstrate climate leadership. That was right before the Paris Agreement was signed. The company then filed a $15 billion case. President Trump came in, allowed the project to move forward. So the company dropped that case. Then Joe Biden was elected and immediately canceled the project again. and the company again sued for $15 billion. Now, the US has thankfully won this case, but it was at the jurisdictional stage, and essentially the reason was because the US and Canada had been smart enough to remove ISDS when they renegotiated the North American Free Trade Agreement. The last case was only launched last year. Zeph Investments is a company that was pursuing a thermal coal mining lease in the Galilee Basin that would have generated 1.58 gigatons of carbon dioxide emissions, which is roughly equal to what Australia emits in total over 3 years. There was a landmark court ruling that recommended against the issuance of a mining lease because the project would have brought unacceptable climate change impacts. And the Queensland government followed this recommendation, which resulted in a claim for $69 billion Australian or 45 billion US, and that case is ongoing. Going beyond existing cases, I have done some work with colleagues at Boston University to try to predict where future cases might arise. In a study published in Science in 2022, we looked at oil and gas projects that would be canceled if the world followed a 1.5 degrees Celsius pathway. And we found that at least 19% of the world's oil and gas developments that would need to be canceled under such a pathway are protected by investment treaties. And that is probably quite an underestimate because of the limitations of our methodology. We estimated the liability for states of canceling those projects could be up to $340 billion, which is more than the total amount of public climate finance globally in 2020, which was $321 billion. And we were only looking at upstream oil and gas. Litigation risk would be much higher if we factored in coal mining and infrastructure such as pipelines. I think the most important part of our findings is when we look at the distribution of these risks around the world. So clearly some of the states that are facing the greatest potential liabilities, which is shown in this map in the darker regions in red, have very little capacity to deal with ISDS cases or to pay out large awards. And in another paper, we put this into some broader context. So in the top map here, we look at the relationship between a state's climate vulnerability and the value of all their treaty protected oil and gas assets, and sort of look at the relationship between that and their GDP. So Mozambique, for example, is in the top 25% of the most vulnerable states to climate change, yet the total mean value of all its treaty protected oil and gas assets, which is 29 billion, is nearly twice the size of its GDP in 2019. So the bottom line here is that this is highly unjust. Any ISDS awards against these states for taking action on climate would be a transfer of finance from the global south to the global north, which is the opposite of what should be happening. Finally, even if none of these cases ever materialize, ISDS can still have a negative impact on climate policy. So the idea of regulatory chill is that governments, when they are threatened with an ISDS case, will reverse course or delay action because they're concerned about the cost of defending an award. So one example here is that the climate minister of New Zealand is on record as saying that the country did not join the Beyond Oil and Gas Alliance, or BOGA, as a full member because the government was concerned that a Paris-aligned phase-out of oil and gas would have sparked ISDS claims. So just to sum up here, fossil fuel firms have had a great deal of success in ISDS, and the awards that they have won have very likely been reinvested in more fossil fuel projects, which is exacerbating the climate crisis. It also limits the fiscal space of governments, especially when we're talking about governments in the global south. It's taking funding away from mitigation and adaptation where it should be spent. And even the threat of a large award can be sufficient to chill climate policy. Again, reiterate, my main concern is that this is going to happen in the global south. And finally, large ISDS awards, which I think we'll hear more about how these awards are calculated in the next presentation, can sort of cancel out climate finance and reverse the direction that finance is flowing, which is highly unjust. And we're supposed to be all trying to achieve a just transition. So thank you so much. If anybody wants access to any of those articles, please just send me an email. I'll be happy to share them. Thanks.
Thank you so much, Carla, and thank you for condensing a huge amount of content into a 10-minute presentation. And just to reassure attendees that we will circulate Carla's presentation along with the recording of this webinar, so you have access to it as a resource. I'd like to pass now to you, Simon, to speak a little bit more about how this regulatory chilling effect that Carla mentioned actually plays out in practice. So how do you see in your legal practice in representing sovereign states that have been that have had an ISDS claim initiated against them? How do you see that use or the threatened use of ISDS functioning as a form of corporate influence over governmental decision making?
Yes, thank you, Sarah. And first of all, it's a pleasure to be here. Thanks for having me. So you have to recall that ISDS replaced the old system of diplomatic protection, where companies had to convince their state of origin to espouse their claim and assert it against the host state of the investment. With ISDS, companies are now free to directly initiate claims against the host state. There's no longer that filter. When companies do so, it is to either dissuade the government from taking certain measures, undo measures that have already been taken by the government, or get the government to pay compensation in connection with those measures. So think about the three branches of government: the executive, the legislative, and the judicial branches. Companies use ISDS to challenge the exercise of government powers by all three branches. I'll give you three examples from my own practice. The Ministry of Mines in an African country cancels a license after the mining company has failed for many years to even build the necessary infrastructure or obtain the required financing. The company files an ISDS case against the state, claiming hundreds of millions of dollars in compensation for lost future profits to be generated by this inexistent project. The mere threat of a potentially huge award of compensation was sufficient to bring the state to the table to negotiate a settlement. Second example, this time concerning the legislative branch. Parliament in a South Asian country enacts a law aimed at curbing tax avoidance. The tax authorities then ask that a multinational company pay tax in connection with a large acquisition based on the new law. Instead of paying the tax, the company files an ISDS claim against the state, and the arbitral tribunal finds in favor of the company. The state requests annulment of the award on a number of grounds, but it eventually accepts to settle and not to apply the tax to the company. Third example, concerning the judiciary. The CEO and main shareholder of a media company in the Middle East is condemned criminally for money laundering using the investment company in the host state. Instead of serving his convictions, he escapes the country and initiates an ISDS case, arguing that the convictions by the courts of the host state prevented him from managing the company and deprived him of his investment in breach of the treaty. So in the first case, the company used ISDS to pressure the ministry to settle, even though it had failed to comply with its obligations to develop the project. In the second case, the claimant used ISDS to circumvent the application of a law designed to curb tax avoidance. In the third case, the claimant used ISDS to avoid serving his criminal convictions and to seek $500 million in compensation. The bottom line is that ISDS can be a powerful tool for pressuring states at all levels of government and with respect to all kinds of sectors and measures. That includes, of course, climate policies, which are in direct tension with the interests of fossil fuel companies.
Thank you so much for that response. Companies can also bring legal claims against their host governments under the domestic court system of those governments. But we don't really talk about this as creating regulatory chill. Why is ISDS different?
Well, I'll mention three key differences, and Professor Tienhara already touched upon some of these. First, the legal standard that arbitrators apply. You've heard about this fair and equitable treatment clause. In ISDS, the claimants usually rely on that fair and equitable treatment, or FET clause, as we call it, of the treaty, which is not available in domestic legal systems. You can find a common version of the FET standard in the Australia-Pakistan BIT, which reads quite simply, quote, "Each party shall ensure fair and equitable treatment in its own territory to investments, close quote. You can see why this kind of vague language has opened a Pandora's box in ISDS. Give that kind of clause to multinational companies with armies of lawyers, and they can easily build an argument that any state conduct that they don't like is unfair or contrary to their legitimate expectations, concept that Professor Kienhauer mentioned. It's a dangerous standard, and it is the one under which most ISDS decisions against states have been rendered. A second key difference I'll mention is that ISDS claims can lead to high damages awards, often in the hundreds of millions or even in the billions of dollars. A recent study shows that the average ISDS award in the period 2010 to 2019 amounted to $207 million. You can understand why a government would think twice about adopting certain regulations, given this risk of high awards. The third key difference has to do with the arbitral process. Unlike judges in domestic courts, arbitrators who sit on ISDS tribunals are appointed for the specific dispute brought before them. They are usually named by the parties themselves and arbitral institutions. Once the case is over, the tribunal is disbanded and the arbitrators need to wait until the next appointment. So arbitrators have a financial incentive to let cases proceed. And those who want to be reappointed by the claimants, which by far outnumber the respondent states, they have an incentive to rule against the state and award significant damages. And as mentioned before, there's no appeal in these cases. By contrast, judges in domestic courts usually sit on a busy docket and have no hesitation in dismissing claims that have no legal merit. Also, keep in mind that arbitral proceedings are generally confidential. There's usually no transparency of the proceeding and therefore no monitoring by the public of the conduct of cases and hearings. This can seem surprising since we're dealing with awards that will eventually have to be paid taxpayers' money. So I'll stop here in terms of the key differences.
Yeah, thank you. So it's useful to have that explanation of the size of awards that can be obtained under this system as compared to a domestic court system. But isn't there just an argument that companies who bring ISDS claims are simply pursuing their legal rights to compensation for their losses?
Well, I think that's the idea in theory, but the reality we see in practice is very different. We're seeing that claimants are actually asking for much more than what they're entitled to. A recent report from the UN Commission on International Trade Law, or UNCITRAL as we call it, observed that companies claim 3 to 5 times what they're actually awarded on average. Claimants often exaggerate their claims to generate a so-called anchoring effect. The idea is simple. You use a grossly inflated number to anchor the tribunal's mind to that number, with the objective of influencing the tribunal to award maybe a lower, but still indefensibly high amount. Given that there are no sanctions for this kind of behavior in arbitration, it has become a routine practice to inflate claims. And claimants are actually increasingly successful at obtaining large awards from tribunals. The UN report I mentioned observed that it took 21 years from 1981 to 2002 to reach $10 billion in cumulative awards of damages in ISDS. This number then doubled to 20 billion cumulative awards in just 4 years, between 2002 and 2006. And then that amount doubled again in 4 years to 40 billion from 2006 to 2010. The current cumulative number is not mentioned in the report, but you can bet it at least tripled to around 120 billion if we count other recent mega awards that have been rendered. So how do claimants and tribunals get to these high numbers? So they generally result from the use and often the abuse of a particular valuation methodology called the discounted cash flow methodology, or DCF. So in basic terms, the DCF method consists of projecting cash flows to be generated by the investment over its anticipated lifetime, and then applying a discount rate to determine the present value of those cash flows. So it's an exercise in predicting the future. It's one of the methods commonly used in business when performing valuation exercises. but is highly dependent on the quality and reliability of the inputs that go into the DCF model. If the company has been operating profitably for a long time, then it has generated inputs on revenues, costs, and other parameters that can more reliably be used in a DCF model. But if it hasn't, as in the case of a new project with no history of operation, projections are inherently speculative and would be looked at with caution by any potential investor. That's the reason why the traditional view under international law was that the DCF method could be used only when the business at issue was a going concern, the track record of profitability. That's the traditional rule. Initially, ISDS tribunals generally respected this traditional view. But in more recent times, tribunals have increasingly accepted to apply the DCF method, even in the absence of a going concern with a track record of profitability. For example, in the Tetian Copper v. Pakistan arbitration, the tribunal used the DCF method to award over $4 billion in compensation, even though the mining project at issue had not started and the company had not even obtained all the required authorizations to do so. Far from a track record of profitability, there was no operating project at all. Yet the tribunal used the DCF method to award compensation for lost profits for the anticipated 56-year duration of the project. That case was, by the way, decided based on the fair and equitable treatment of the Australia-Pakistan treaty I mentioned before. In that case, Pakistan could not pay and eventually had to settle and let the mining company back into the project. This is another example of a company using ISDS to influence government decision-making. Just one more example, the tribunal on the Rock Hopper case mentioned before also used the DCF method to award compensation even though the oil project at issue was not built and the company had not even received an actual exploitation permit. So to go back to your question, we see in practice that claimants are routinely presenting grossly exaggerated claims, often based on speculative DCF models, and they're increasingly successful in getting arbitrators to accept their claims.
Thank you so much, Simon, for that perspective as an ISDS insider. I'd like to turn now to you, Adam, as an institutional investor, and to bring that really crucial lens to this discussion. So, Adam, why do you think all of this matters for institutional investors who care about climate change?
Thanks, Sarah. First of all, it's just simply great to hear and learn from real experts like Carla and Simon in this little note. Well, so thank you both to them and for having me join in. I guess the simple answer is that every conversation that you and I have, or that we have amongst institutional investors on climate, gets down to the critical importance of regulation and policy. And regulation and policy is a function of everyone who engages with it, that influences, that advocates for it. It's not created in some sort of vacuum. So to the extent that ISDS can be influential in shaping that policy environment, testing it or chilling it, as we've been hearing about, then that must be of importance to investors. So if ISDS claims deter the right policy settings for the just and orderly transition that we need, then that's just simply heightening the already pretty alarming levels of systemic risk that we face as institutional investors and that we have to navigate. And I can speak from our perspective at Relpen. We're a long-term diversified investor. We're trying to secure our members' futures. And so the climate risk, the policy environment around it, the systemic risk, that really deeply matters to us and whether we can achieve essentially our purpose as an organization. And that's particularly true, not just about individual companies that we hold or individual projects or assets, but at that system level. So it's that kind of universal owner mindset that I think a lot of people will identify with. And for me, that's the big focus here. There are absolutely other issues here, like the cost to pursue these claims, potential reputational risks that we're then associated with and exposed to as investors. But for me, that big policy setting, influence, chilling, that's the real kind of golden center to why this is so important.
Yeah, thank you for that. I think that's a really valuable perspective. And I know that you're a member of the IIGCC lobbying working group, and I wonder what parallels you might draw between ISDS and negative climate lobbying.
I think there are lots of parallels there. So I think you can see ISDS as a kind of form of corporate influence akin to that negative climate lobbying, as you mentioned. I think it can be seen as deterring that right policy environment. The examples that Simone was giving there for sure show that and demonstrate that. The way in which it can kind of prolong the status quo, favor incumbents and their practices. And so for me, that is just so tied up and parallel to lots of the kind of climate lobbying, climate advocacy discussions that I think institutional investors are slightly more familiar with. But I think actually both topics probably just don't get the attention they deserve either. I think that's a much greater issue for ISDS than it is for the climate lobbying, which I think has recently really received an uptick investor attention. But I think it's still the same for both, because we get back to that point of the real crucial nature of a conducive, right policy and regulatory environment to manage systemic risk. And I say that from the perspective of, are investors paying enough attention to this subject? But I also feel that it probably doesn't get the same attention that it deserves from within companies and within corporates. And for me, there's this really strong element that policy advocacy, understanding, influencing, and advocating for the right policy environment and regulatory regime should be a really core part of an organization's strategy. There should be this really strong thread from ultimately your objectives you're trying to achieve as an organization, your strategy, where you spend your OPEX and your CAPEX, how you report through. And, you know, the advocacy and engagement on that policy is an important part of that. Something you do directly, something you do indirectly through your trade associations. And it should have that alignment, not something that's pulling it off course or kind of working in tension with it. And too often, I think that the notion of policy advocacy integration, just even at the very basic levels of different internal teams within an organization talking to each other, is just not fully there yet. And so I think that there's so many parallels for me as I'm learning, honestly, about ISDS to the kind of slightly more familiar subject of climate policy engagement that's going on. And, you know, at the root of both of them is that I think that they should be further up our agendas, but also within corporates as well.
Yeah, thank you. I want to touch a bit on transparency now, because I think towards the end of his intervention, Smell mentioned that this regime of ISDS is sort of notable in its lack of transparency, particularly compared to a domestic court system where anyone can walk into a courtroom and observe proceedings and can see court documents relating to a case. Whereas in ISDS, you know, any discussion of numbers of cases has to be hedged with the fact that these are known numbers. These are the cases that we know about. There are many, many more that we don't know about existing at all. Or if we know that they exist, we might know actually very little about the claim and what arguments the company is making to support its claim for compensation. So I'd be interested to hear from you about how you feel having more of a light shone on that regime, more transparency. How would that be beneficial to you as an institutional investor?
Absolutely. So, I mean, at one level, greater transparency and information, that's just simply about building a more accurate and complete understanding of a business, of a company in this case. And given the potential materiality of ISDS, as we've been talking about, this transparency could, you know, be a material help on that better understanding. So that then leads you to be able to better judge risks and opportunities and so on, and really understand the underlying investment thesis that you might be underwriting. But there's also a kind of direct set of potentially really material information that can be valued just in that, but also I think a series of kind of signals or signs or indicators that are really helpful that it could reveal about a company. So I'm thinking the kind of governance of an organization, for example, the potential inappropriate use or unsupervised use of ISDS, the level and detail of policy dependencies that a company is trying to navigate that kind of real risk exposure, It could give a forward-looking strategy signal about their intentions and where they're heading. And all of those kind of things together, I think, build up a much more nuanced picture of a company, which is really valuable for an investor. The other thing I would say, and this links to what Simon was talking about in terms of the DCF type of modeling or the projections type modeling. And as investors, I think we're always looking for topics or conversations where you get a real insight into a company through your engagements, probably not just, you know, a standard response to a standard question. And to me, I think ISDS can be one of those topics. So the way in which they build assumptions that go into their claim calculations, that can be super, super powerful insights. And I think a topic that institutional investors might be more familiar with, where we're engaging, for example, on high quality accounting disclosures in financial statements, pressing for more details around scenario analysis, pricing, commodities assumptions. Those are all these kind of things that maybe ISDS type conversations and claims could help reveal at a level of truth and kind of reality that a company's pitching forwards. And the kind of real go, no go, CapEx decisions, project decisions, I think that those, again, can be revealed through these kind of conversations. And so I'm always looking for those kind of pieces of information that kind of go beyond and kind of go into the real insights of how a company's truly thinking strategically, how it's truly building out its model of the future and how it can see its role within that. So I think that conversations around ISDS and increased transparency of that could be very, very valuable from that front.
Yeah, thank you so much for those really useful insights. So I wanted to move the discussion on now in the next or the last 15 minutes to have a quick kind of whip round of views from the panel about how institutional investors who are interested in the topic of ISDS, who see the relevance of it to their work in some of the ways that you've articulated so well, Adam, what can they do about it? How can they start integrating this? And so maybe to stay with you, Adam, for the first question would be, how can institutional investors start bringing the topic of ISDS into their engagements with companies?
I mean, it may be a naive answer, but, you know, just ask the question, do some research, lean on experts, you know, read up what Kyla is going to share and then ask, start the dialogue. You know, it can just be simply trying to understand the governance around ISDS, who decides, who oversees, what policy commitments does a company have, how involved is the board in overseeing this or looking at it. It could be trying to pick on specific previous cases that we know have happened and trying to unearth more information about that. What led to ISDS being the chosen route forward? Did they exhaust every other strategy available and so forth? How does their use of taking an ISDS claim align to its other stated strategy and goals and so forth? And what lessons can they learn from previous claims? So I think that, you know, just start with some simple fact-finding questions, and I think that they can often reveal a lot. We mentioned in the previous part parallels with climate lobbying, and so the go-to standard there is the Global Standard on Responsible Climate Lobbying, and I think that gives a really sensible framework for what you could apply to ISDS as well. So it's got indicators around policy and commitment, governance, actions and disclosures. So that kind of gives a kind of really good starting point and simple list of questions. I said it was a naive answer, but I mean, I've done it myself, and potentially a bit naively, but so some of our priority engagement companies who I think you described them, Sarah, once as frequent flyers on the ISDS program. So I've asked them about this, and to be honest, the response and reaction mostly showed to me that very few, if any, other investors are asking these questions and taking these topics to companies. And so that's just valuable information in of itself, but for me also that supports what I was saying earlier about it deserving a place higher up the engagement agenda, and then it can hopefully reveal much more and there'll be greater transparency coming through from the industry around it.
Yeah, thank you, Adam. And maybe just a small plug for our insight on this topic does have in an annex at the back a few engagement questions that investors could use to kind of kick off some of these discussions that you've described. Kyla, I might turn to you now and to stay with this idea of investors bringing the topic of ISDS into their engagements with companies. And I could imagine some of them in doing so might get objections or responses from a company to the effect that ISDS is a legal topic. It's a question for the lawyers. It's a sort of a discrete technical area rather than a sort of policy or political influence issue. How would you suggest that type of objection could be responded to?
Yeah, so just briefly, because I see some excellent questions in the chat as well. I think that it's very clear now, we have plenty of evidence that particularly in the fossil fuel sector, but also in areas such as mining and so forth, that there's a lot of awareness in the industry about this mechanism, about how to use it. There's a lot of experience. So they clearly know it's there. And we also have plenty of evidence of climate obstruction. There's a burgeoning literature about how much has been done by a lot of companies to try to block climate policy. We don't have too much yet on the intersection of these. It's very hard to get into, get much information on what companies are actually using in their lobbying. But I have absolutely no doubt that the threat of this mechanism is being used very frequently in lobbying efforts. It's only one of the many tools that they have in the toolbox, but I think it's a very important tool. And I think that it needs to be recognized as that. We know that actually taking a case forward can be quite expensive for a company, although there are these mechanisms now where they can get third-party funding, so they don't even have to pay for it themselves. But so the actual launching of a case might be, a big deal for a company to take that forward. But it's absolutely not an expensive mechanism to use just as a threat. And I think that that means that it's a cheap tool to use. It's an effective tool, I imagine, especially if you're dealing with governments that really don't have as much experience with ISDS, don't have as much resources available. So I just can't imagine that they're not using it in climate lobbying. So if climate lobbying is something that institutional investors are focused on, then ISDS absolutely has to be part of that as well.
Thank you so much. I can see we have a flurry of activity in the Q&A, which is great. So I'm going to ask one more question to Simon about potential entry points for institutional investors into the ISDS conversation, and then we'll go to the Q&A from participants. So Simon, we know that there are a number of broader reform efforts currently underway by governments to try and limit some of these risks to climate policy space and policy space more generally that's coming from ISDS. And in your view, are there roles for institutional investors to try and support that reform process that states are leading?
Right. So at the moment, I would say that the representatives of the private sector who are active in reform discussions are essentially advocating for leaving the ISDS system as it is. You can see that, for example, at UNCITRAL Working Group 3, where government delegates, NGOs, and the private sector are debating the reform of ISDS. In this and other fora, representatives of the private sector use the old rhetoric that if developing countries terminate or change the ISDS system, then they will no longer receive foreign investment. You can see that rhetoric deployed, for example, at UNCITRAL by a legal counsel for ExxonMobil, who is the representative of an organization called the Corporate Council International Arbitration Group, or CCIAG. Institutional investors who would like to curb the use of ISDS to challenge climate action and other legitimate government policies could be more present in the relevant fora. One way to do that would be to send a representative to the meetings where those topics are being discussed. Another way could be to coordinate with existing representatives of the private sector to ensure that institutional investors are properly consulted and that their views are being heard and taken into account. Beyond that kind of participation, institutional investors can also directly communicate expectations to companies in their portfolio about the inappropriate use of ISDS. Adam was broaching on this. Example, when it comes to climate change, they may wish to develop an investment industry expectation that ISDS proceedings should not be brought against non-discriminatory public interest measures designed to address climate change. These could be ways to get more involved.
Fantastic. Thank you so much. So we have another 8 minutes for our webinar, and I can see quite a lot of questions coming through the Q&A. I'm going to hand now to Bart-Jaap Verbeek from SOMO, who is one of the co-organizers of this event, to direct traffic in terms of the questions that we're getting. I will just say, if we don't manage to get to all of the questions in 8 minutes, we will endeavor to do a follow-up email covering off some of those outstanding questions. And thank you for sending them through. Over to you, Bart-Jaap.
Yeah, hi. Thanks a lot, Sarah, and many thanks to all the speakers for their great presentation. So we have a lot of questions coming through at the Q&A section. So just to start off, I think I'll group a couple of questions together. So these first questions, I think, would be directed at Simon. So the first question is, does the arbitration industry incentivize investors to bring cases? A second related question, could you cure the monetary consideration of arbitrators to let proceedings continue by devising a rolling basis of arbitrators eligible to sit on the panel in a dispute? And a third question, that similar question is, a significant part of the problem appears to lie with the arbitrators with respect to the manner in which they balance public and private interest in their arbitral decisions. To what extent is the regulation of the arbitrators themselves a question that has or can be looked into with respect to ISDS and climate change?
Yeah, thank you, Bart-Jaap. So I'll try to be quick. There are a lot of questions. So on the first question, does the arbitration industry incentivize investors to bring cases? I would say there's no doubt about that. And in particular, we have seen, I mean, you have to remember who are the players involved here. You have law firms, their business for most of them is to, in this field, is to have clients, companies that are going to be claimants in those cases. That's how they're going to generate fees. And then you also have third-party funder, and their business is to fund cases that are going to be brought by companies and their lawyers. And so everyone has a financial incentive in those capacities to see more and more cases brought before international arbitrators. So the second question, I'm not so sure what a rolling basis of arbitrators would mean, but just to mention that there are a lot of discussions at the moment on the reform of ISDS, especially the procedural mechanism. Should we keep a system with these arbitrators in place, or should we move to a system with permanent judges instead, like we have in a number of international courts and tribunals? So there's a lot of debate about some of the issues that Professor Tienhara mentioned, the double heading, and this is being discussed, and there are current reforms being on the table. Now, that being said, those reforms do not really focus on the substantive side, those high damages awards that is being mentioned, but there's a lot of reluctance to put that on the agenda. The reform of the fair and equitable treatment clause, that's not really on the table at the multilateral level. So just to recall that there are a lot of limits. Maybe I will stop here, and so that I can give an opportunity to the other panelists to answer some questions.
Great, thank you so much for answering these questions. Maybe another question, maybe probably for Kyla. So is there a viable approach to substantiate a counterclaim based on environmental damage in the host state? Consider a scenario where a fossil fuel investor initiates an ISDS claim challenging a coal phase-out policy, and the state invokes its right to regulate in the context of climate action policy space. In this situation, can the state seek compensation for damages incurred, such as air pollution in the region where the investment was operating? If so, how could they quantify it? Thank you.
So very briefly, it is possible to have counterclaims, although they are often rejected by tribunals, so it's quite a difficult thing to achieve. However, it should be understood that a counterclaim can only lessen the amount of damages that a company is going to receive. So it's not particularly effective in terms of actually, getting money that could be used to, in the same way that you sort of a climate litigation case in domestic courts or something like that could actually achieve some setting aside of money to repair damage, deal with health issues and so forth. It's only going to reduce the amount of money that the company will receive in compensation.
Great, thanks a lot. A quick question for Adam. Are there any engagement or working groups investors can join on policy advocacy on ISDS?
So, to my knowledge, not just focused on ISDS. Sarah mentioned I'm part of a working group on climate lobbying as a broader subject. And there's that responsible climate lobbying standard, which explicitly defines lobbying to include litigation. So that is a clear hook for that. The broader institutional engagement initiatives in this space, such as Climate Action 100+, Climate Engagement Canada, Net Zero Engagement Initiative, and others, do specifically have climate lobbying as a focus, as a one of many criteria that they would look at. And as I said, that will be linked to that responsible standard, which then can link through to ISDS. So there's a mechanism to get to it. I don't know of one that's an initiative that's purely focused in this space, but the lobbying theme as a whole is getting a lot more prominence, and it has those bases and hooks into kind of existing large-scale initiatives. And so I think that's the most effective way in which you could get ISDS on those collaborative engagement agendas.
Great, thank you so much. I think we can do one more question. Maybe another question to Kyla. Can you speak to the prospects of strategically using ISDS to achieve climate-aligned outcomes? For example, a renewable energy company bringing a claim against the developed state for its continued use of fossil fuel subsidies.
So unfortunately, I don't think ISDS is useful for achieving climate-aligned outcomes. There have been a lot of renewable energy cases, particularly against Spain, for making changes in its feed-in tariff. However, if you actually, this is used all the time by the industry as a greenwashing technique to say that we need ISDS for the green transition. But if you actually look at the cases, you can see that the changes in policy that were made were, I think, appropriate and only reduced the amount of profits that the companies were making. A lot of companies kept investing afterwards. It was really just excessive the way these awards were going out, and there's also no evidence to suggest that that renewable energy companies are actually incentivized by the existence of ISDS, so it's not facilitating green investment. In terms of that specific idea of bringing a claim against a state for continued use of fossil fuel subsidies, I see that as very unlikely because fossil fuel subsidies are well established. And usually what happens in ISDS cases is that there's a change in policy that is challenged. So if you're entering into an environment as a renewable energy investor and there's already plenty of fossil fuel subsidies, you're not going to be able to challenge that. And even if there was an increase, I think it would be a real stretch to say that that would be a viable claim. So unfortunately, I don't see that as a pathway at all for strategic use.
Thank you so much, Kyla. Thank you so much to all of our panelists for your time, and thank you attendees for all of your questions. And I do apologize we didn't get to all of them, and we will endeavour to include a response to them in the follow-up email that we'll send out with the recording, with the slides, with the briefing note that I've referred to. So enjoy the rest of your day, and thank you for joining us. Bye-bye.